they can't do things for them all of a sudden. They can't do their taxes for them anymore. They can't make medical appointments for them anymore. So there's a lot of things that people discover after their child's gone off to school that they don't have the ability to do anymore. Um, there's a lot of things that I didn't have when I went off to school that my parents needed as well. That we discovered very shortly thereafter that I suddenly had to do things that I had never done before. So welcome everybody. Today, our seminar is our webinar, excuse me, is going to be talking about the different documents that your child needs before they go to school. Our August, series this month is all about education, kind of getting close to that going back to school period of time, and when maybe a little different this year, but still that time of year. So next week, we're going to be talking about creating an educational legacy for your child, kind of how, or for your loved one, it doesn't have to necessarily be a child, that you leave through an estate plan and the different sorts of accounts that can be done through, documents you might use, and the impact of those accounts on financial eligibility, FAFSA, things like that. Today, though, I'm going to be focusing on the documents that your child will actually need to have signed or should have signed before they go off, become adults, all of that into school, maybe into a different state. So what a lot of people don't understand is that once your child turns 18, we all understand that that's the legal age of being an adult. But what people don't understand is that their kids now have to grant them authority for them to be able to do things on their behalf. When I went off to school, my parents discovered, oh, we can't file his taxes for him anymore. He has to do that on his own, even though they were really the ones who were still guiding me through it. I was the one who had to do it. Same thing with setting up doctor's appointments. A lot of kids keep their same doctors, even if they go to school out of state. So it's very difficult for them to discuss and set things up with their doctors while they're out of state. The issue you will run into if you do not have these documents is you will have difficulty working with financial institutions, medical institutions on their behalf. But also the real concern is what happens if the child has a disability or an incapacity of some kind. Who can step in and make decisions? Who can get information that they need? And without these documents in place, there's not an easy avenue to get that information. So the 4 documents I'm going to go through today, the 4 key things that your child will need before they go to school, is the financial power of attorney, a healthcare power of attorney, a HIPAA authorization, and a living will. So those are what we sort of collectively call the disability documents, because they're the documents that will allow someone to step in and help you if you become disabled or you have an incapacity. So with a financial power of attorney, that's the document in which you or your child will designate who they want to step in and help them if they have an incapacity financially. Now, most financial powers of attorney, and ones that our office drafts included, are actually what we call immediately effective. So what that means is the person granting that authority, the moment they sign it, the person they've listed as an agent has the ability to step in and help them financially, making decisions, opening and closing bank accounts, talking to a financial planner, doing their taxes, anything like that. As long as it's listed in the document as an authority, if that is an immediately effective power of attorney, the agent can start acting right away. Obviously, with children going off to school, this is really important because at 18, most kids don't know how to manage finances. I mean, they're still learning all of that. So you as a parent having the ability to step in and help is really important, and help guide them and potentially sign off on things for them if they can't themselves. With the financial power of attorney in particular, there's a lot of financial decisions that parents are still making for their kids. They're still maybe the major source of financial support. The more concerning thing that your child should have in place in particular is when it comes to healthcare decisions. Just to give you an example, there's a few years ago, a client of our office, part of the reason they came in to talk to us was because a family friend of theirs, their child got into a car accident and was in the hospital, and did not have a HIPAA authorization. He did not have a healthcare power of attorney. He did not have a financial power of attorney, to my knowledge. Basically, he did not have these documents in place. And the child was 18 or 19, so legal adult. But the issue they discovered was that, well, they go into the hospital and they say, "Where's my child? You know, what room is he in? How can I go visit him?" And they had to say, "We can't tell you any of that." So without these documents in place, you're going to run into a lot of difficulties if there's a health emergency of any kind. So the two healthcare documents that you really want to have in place for the, during lifetime decision making is a HIPAA authorization. So HIPAA authorization is simply basically a list of names that somebody has signed off on that says, these people are authorized to get medical information on my behalf, talk to the doctor, and figure out what's going on with me. Basically as simple as if you call the hospital, the doctor can tell that person, "Oh, yes, they're here." The healthcare power of attorney is where the decision-making authority comes into effect. So HIPAA does not have any decision-making authority. It's simply a list of names of people who can receive information. The healthcare power of attorney, just like financial power of attorney is for financial decisions, is where your child or your loved one will list the people that they want to step in and help them make medical decisions should they not be able to do so for themselves. So this includes things like if they can't decide, if they're in a car accident, medically induced coma, potentially something like that, they can decide, okay, we're sending them to this hospital, or we're going to authorize this treatment. It's the list of authorities you're granting to somebody to help step in and make medical decisions on your behalf, should you not be able to do so. And again, once somebody is 18, and I can't stress this enough, without these documents in place, a parent does not have those authorities automatically anymore. The law, unfortunately, does, or potentially fortunately, depending on your situation, I suppose, has basically decided we are not going to assume that families get along. And because we don't assume that families get along, once somebody is a legal adult, they have to actually authorize someone else to step in and make those decisions, even if it does end up being parents. One of the other documents as well is what's known as a living will. So a living will is the document in which somebody is basically saying, I don't want to be kept on life support if I do not have a chance of getting better, if it's just merely prolonging my death by a matter of days or hours, some period of time where this is only prolonging the process. It is not going to treat me in any way. This is something that's really important to have in place as well. For anybody, again, but even a child going off to school, the situation you can find yourself in without this document is if somebody is in a situation where they are on life support and they do not have a living will, you can run into trouble of making the decision of removing somebody from life support, of following their wishes. Now, whether or not those are wishes or those are their wishes, that you may know that, but without that document in place, you can run into some difficulties. So this document is really, nobody ever wants to think that their child is going to be in this situation, but having it in place is very important so that you can make the right decision for them if they can't themselves. And this is something that you want to involve your child in. You want to, they are adults, so they are the ones that have to sign off on this. They get to name who they want to step in for them. It very likely will be you, but they get to decide that. They get to decide whether they want to be maintained on life support or not. And these are discussions that you need to have with your child before they go off to school. Obviously, it's not the fun send-off people hope when they're going to college of, if you're incapacitated, what do you want us to do? But they're important decisions nonetheless. And I should mention as well, we do have the ability, if you have signed up via Zoom, we have the ability to have questions and answers. So if you have any questions for me of what types of considerations go into naming certain agents, or any just general questions on powers of attorney, for registered participants, you can actually send in questions, and we'll be able to hopefully answer them in real time, depending on if we can get the if the chat box is working effectively. So the other thing too is for registered participants, we do have, I apologize for the glare, but we do have the basically a list of these different documents, the four financial, or not, excuse me, financial documents, but the four disability documents that every estate plan needs and every child needs before they go to school. We also are mailing out a book that we have written on planning for younger families. So that includes, people with young children, or people with, the newly adult children, and the types of considerations that need to go into their planning. So again, with these documents in place, you can make those decisions for your kid. These are not an estate plan in of themselves. They are certainly a portion of an estate plan, but they're a way to get your child started on these, sort of on their path to adulthood, and making sure that you can step in and help them. The big thing with doctor's appointments, things like that, I know I ran into when I was going into college, is my primary care physician was still in my hometown, and I did, as any young adult did, I still said, hey, mom and dad, can you call the doctor and set up that appointment for me for when I come home? And ran into the situation of, nope, sorry, can't do that. He has to call us. So that was the issue I ran into with that type of, without that document in place. With a healthcare power of attorney as well, one of the big things to keep in mind is that just like the financial power of attorney, that is actually what we would refer to as immediately effective, meaning your child does not have to be declared incapacitated for you to be able to step in and help them make decisions. But what it does also mean is that as long as they do have that capacity to make decisions, you can't override them. So they still have full control over their health. They still have full control over the healthcare decision making, but you do have that immediate authority to step in and help should you need to. And it's one of those things where just people don't consider this. Without these in place, if your child does become incapacitated, the issue you will run into is, in order to get these authorities, you have to go through a process known as guardianship. Without powers of attorney in place, the only way to get that authority is for a court to grant it to you as a guardian. That is an avoidable process if you have these in place. With a power of attorney that's immediately effective, nobody has to be declared incapacitated, and you don't have to get the authorization from the court to be able to step in and help them. Guardianship is not a fun process if you can avoid it. I mean, you have to petition the court for guardianship. The court will appoint a what's known as a guardian ad litem. It's really an independent attorney whose job it is to make an assessment of the individual and see if they actually, need the guardianship, if the person who is nominated as guardian is is fit to act in that role, things like that. And potentially, if it's a type of incapacity where somebody is still able to contest the guardianship, say, I don't need that, you can run into issues. That's when the court has to appoint another attorney to basically fight against the guardianship. So if you can, at this time, talk with your child and figure out who do you want in charge if something like this happens, who do you want to be able to step in and help you, even if you have capacity. Those are the types of decisions you need to make now, or they need to make now with you, in order to not run into difficulties down the road. I know in particular, a lot of concerns around health right now are with everything going on in the world, and that's understandable. So having these types of documents in place so that you can step in and help them is just essential, honestly. So the one consideration too with a healthcare power of attorney that I always bring up with people is The healthcare power of attorney is the individual, along with the acting physician, who has to honor the living will at the time that that decision needs to be made, meaning they, along with the physician, have to sign off on any removal of life support. So it is very important to talk with your child and understand what their wishes are, one, on that, but also be honest with yourself and decide, is that something that you are able to do? Are you able to make that decision? Some people can't, and that's, you know, emotionally, and that's not a weakness or a fault. It's being honest. And if you can't make that decision, somebody else may be the better fit for that agent. With healthcare powers of attorney, both parents can't be the acting agent. It does have to be in an order. So, you know, your child is going to probably pick one of you over the other at that point, and they sort of have to. So that's okay. But the financial power of attorney can be co-agents. They can act together. So in that instance, you can have the ability to both act on behalf of your child. In particular with financial powers of attorney, I mean, that is a very easy document to use sort of remotely. There's a lot of decisions that can be made over the phone. There's a lot of, you know, online access, things like that. So even if your child is going to school in California and you're here in Wisconsin, you can still make those decisions for them and on their behalf. With a HIPAA authorization, again, they may have many of those signed at many different medical institutions by this point, but having a kind of a standard one that you can send out to different doctors' offices, you know, wherever they may be located, is important, because then you don't have to get them to sign a new one every time they go to the doctor. So the big thing to consider too with the healthcare power of attorney, the HIPAA authorization, and the living will, those three documents you really want to make sure that you have on file with your primary care physician or their primary care physician, wherever that may be, because that will then make sure that those documents are available to them, to the doctor that they see regularly if something happens. I know, for example, a lot of healthcare networks have their doctor's offices, you know, their primary care offices and their hospital networks have the same system. So you can generally put those documents on file once and have it go across the whole health system, which is nice. The other thing with that as well, those documents, is having them on file is one thing, but a big thing to keep in mind is we also have the ability to send them digitally once somebody has them in like a PDF form. So I know people like me, for example, I don't want to be carrying a big estate planning book with me or these documents with me everywhere I go. So I have them as a PDF on my phone. And so does the agents I've selected for my powers of attorney. So what's very helpful with that is then you can have their healthcare power of attorney, their financial power of attorney, those documents, you can have them on file with you wherever you go. You can always have them with you. You can always use them to make decisions whenever you need to. Now, the big thing making these decisions now is you want to make them while they're here before they go off to school. Without making these decisions now, if something happens, that's again where you're going to run into the guardianship issue. The other thing about financial powers of attorney, things like that, is filing taxes. So you may want to file their taxes now, or not, excuse me, have that authority now so that you can file their income taxes as the year comes around. Maybe you guys all use the same CPA and you just want to do it through there. The HIPAA authorization, the one thing I will say about that is really that's what's going to let you get that healthcare information. A good healthcare power of attorney will have any agent listed on it already authorized through HIPAA. I did run into a situation with a family who they had a healthcare power of attorney drafted somewhere and they came in with it. And the issue was that the loved one had been declared incapacitated or had, or maybe not yet, but was having some cognitive issues. The family couldn't get any information because that loved one had not signed a HIPAA authorization and they had not been able to get that health information, which is very difficult to make a health decision as a healthcare power of attorney agent if you do not have the access to information. So these are not one and done documents. You don't need just a healthcare power of attorney or just a financial power of attorney or just a HIPAA authorization. You need all of these. These are a complete plan, together. They only work properly if you have access to all the information you need and all the decisions you need to make. A part of the reason you want these custom drafted too, you don't want to rely on the state statutory power of attorney form, which anyone can download online. The problem with that document and those kind of generalized for the general public documents is they're not very explicit in the authorities they grant. They are very, very generalized, very vague in what they actually convey. A power of attorney for both finance and health is only as valid as the authorities it specifically grants. So for example, the state statutory form for power of attorney talks about the, here are the check boxes basically of the authorities I want to grant. And it says things like, I'm granting to my agent banking powers. What does banking powers mean? To me, it might mean writing checks, opening and closing bank accounts, setting up, transactions, things like that. But to the bank teller or to the, to your accountant, they might mean very different things. So you want to make sure that if you need the ability to file someone's taxes or you need the ability to write checks for your child, that you have that specifically granted. You do not want to be stuck in a situation where you're trying to argue semantics over what a power of attorney does and does not convey. Or worse, you don't want to run into a situation where that authority that you may need is expressly not included or just not even mentioned once. That's when you're going to run into an issue of somebody could legitimately say, I'm sorry, this agent does not have the authority to do X, Y, and Z because it is not stated in this document. And that's the same thing with healthcare powers. If you need the ability to potentially transfer someone to a new medical institution, you want that authority in there. You don't want it to be in a situation where it says, oh, as a medical power of attorney, I can, decide what type of treatment they're getting, and then it just ends there, or it's just too vague for anybody to actually step in and help. HIPAA authorizations are not really, in general, they're very simple. They for the most part say, here's the list of people that I can actually give information to if I'm a medical provider. But with a healthcare power of attorney and a financial power of attorney, those do have to be very explicit if you want them to be effective. The one thing you don't want to be overly specific in potentially is the living will. You don't want to go through and potentially say, oh, only in the event of this health situation can I be removed from life support. Because I know as an attorney, my fear would be, am I limiting that person too much in the decisions that they're making? I might be able to predict that 100 potential different health situations could come up in which someone might be on life support. But if the 101st happens, that's not covered all of a sudden. And I don't want to potentially limit anyone's end of life decision making. One thing to keep in mind too, especially as your child goes to different, doctor's offices, if they're, going to their campus doctor, or if they are, kind of going in between doctor's offices, is keeping in mind that you want to be careful about signing new healthcare powers of attorney. So a lot of times, I mean, we've all been there. We go into the doctor's office, right? Get a stack of papers, especially if it's a new office, and they say, fill these out, sign here. The issue can be when you sign a new healthcare power of attorney, you are revoking the old one that you had before. So if you go in and you sort of get the standard form that they give to all patients, you're going to be revoking your custom drafted power of attorney that you had specifically designed for you, including the broad authorities you need. That's the kind of thing that we want to avoid if we can. And it happens a lot. People, myself included, are all guilty of when you get a stack of paperwork, sometimes you just start signing. And you want to avoid revoking the authority you've specifically granted, because if you then don't, reinstate the old power of attorney by signing a new copy of it, you're going to run into the issue of, well, now you're bound by the new one. And if they have different agents listed on the new one, or they don't have the authorities that those agents need to step in to make decisions, they are going to be stuck with the new document and what it does or does not allow. Again, I know we're getting towards the end here on time, but I do just wanted to reiterate that these documents are very important for young adults as much as they are for an older adult. I am guilty myself of having gone through college and a lot of law school, without any of these documents in place. And I was lucky that nothing happened. But we can never predict the future. We can never predict what types of situations our loved ones are going to be in. I could walk out of this office today and get struck by lightning, right? That could happen. Knock on wood. But your child, hopefully nothing will happen. Hopefully everything will be fine and everyone's healthy and grows old, but you want these documents in place so that you can step in and make decisions if something happens to them. But also, as a young adult, you want to be able to help guide them in those decisions that they're making themselves. Especially with a financial power of attorney, things like that, your role as agent will allow you to step in and sort of hold their hand for a little bit and say, all right, here's the types of things you might want to be, keeping an eye out on, and I can step in and help you and sort of guide you along the way. No 18-year-old, no matter how responsible, is fully ready to be in complete financial, a financial adult, if you will. They're just not there yet. They haven't had the experience potentially necessary to know what types of decisions to make. So having these in place will really help you make those decisions and to guide them along the way. I know college is potentially going to look very different this year. I know that the whole situation is different, but the health situation going on right now is not a reason to have these done, but it does specifically highlight the need for them. Because if somebody is hospitalized due to COVID-19 or anything like that, having these in place allows their loved ones to step in and help and make those decisions. I know we're kind of running low on time here, but if any questions come up, you can feel free to submit them. If this is something that particularly applies to you or brings up any concerns for you or your loved ones, or your child's about to go off to school soon, please feel free to contact our office. We would absolutely be interested in helping you with these types of decisions and further guidance on these. We offer free consultations. It doesn't cost you anything to come in and talk to us. So if you or your loved one needs these documents, if your child's going off to school, or even if you yourself need these documents, these are not explicitly just for young adults. These are for everybody. So please, if you do need these documents, give our office a call. And we would be happy to sit down and talk to you. We are still doing remote meetings for the time being to keep everyone safe. So, we do phone conferences or we do web conferences. So whichever you prefer and whichever is easiest for you, we can sit down and talk to you.